He wrote, quote, distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. So, Andrew, of the 4 counts facing Donald Trump from Jack Smith, we could talk about the other cases in a moment, which do you think are likely to survive?
Well, it remains to be seen. I mean, I think the issue here is what evidence will survive, rather than it's possible that all 4 counts will survive, but not the panoply of evidence that Jack Smith wanted to introduce. And so I think if you step back, one of the things that we always thought going into today's decision that Donald Trump would not have a criminal trial with respect to the January 6 events before the general election, that this decision was held so long, and now you see why, because they had 6 justices very much leaning in his favor. And so just the delay factor meant that that wasn't going to happen. But one thing that is clear is there will be a factual hearing that Judge Chutkan will be able to hold with respect to dividing official from unofficial activity. And so I think it's really a question of what evidence will be allowed. But as Lisa Rubin pointed out, certain things are off the table. So the allegations with respect to the Department of Justice are off the table. The president has been found, former president has been found absolutely immune, which is a really scary thought. Just think about that. With the president's interactions with the Department of Justice are absolutely immune. Terrifying decision. That alone is sort of unheard of. But it remains to be seen, and for Judge Chutkan to make the initial decision on this hearing. But even that is going to be subject to appeals. But at least that is a way for the public to hear additional evidence from the likes of former Vice President Pence, from prior general counsels and White House counsels who worked for the White House under President Trump. A whole series of witnesses that can be heard at that hearing.
Witnesses who can clearly be subpoenaed for that hearing, whereas some of them tried to avoid testifying to the January 6th commission, which brings me to you, Marcus, as someone who worked on that commission. So what concerns do you have about the prosecution? And I saw you nodding that it's the evidence, not the counts.
Right.
So, will that call to Georgia to find
right.
more votes? Is that official or unofficial? And what Andrew just said about the Justice Department, especially from a candidate who's talking about retribution, does that mean that he can pressure the Justice Department to proceed with indictments and investigations against everyone he's talked about?
Against the January 6th committee. I think that, I didn't want to start there, but I think that's
against Joe Biden? Against
Joe Biden, but that's top of mind. I think sitting in the courtroom today, hearing that piece of the opinion being read out loud, that you have a former president campaigning on prosecuting political rivals. It felt weird to hear then the court talk about wanting to protect the executive branch from a vindictive successor when, the big elephant in the room is the vindictive successor is the individual that they're now protecting with this opinion. Look, Andrew will tell you, I think we will all tell you who's tried cases, you use circumstantial evidence, whether it be communications with one party to prove a greater conspiracy. And this opinion seems to really hamstring the ability to use, evidence of the continued chronological path, starting with the big lie, starting with the pressure in the states, moving to the DOJ. It shows an escalation. The story makes complete sense, which is why our hearings for the January 6th committee made so much sense, because it showed that escalations and desperation. If you're not able to show that escalation, it really, hurts the prosecution from being able to show the jury the greater picture of the crime. And so, look, I still have to digest the entire opinion. I'm sure all of us are still trying to digest it, but it did feel like a blow to hear the rule and the standard that was put out there.
And Andrew, just a quick question. The Mar-a-Lago case, could the former president argue that that was official in some fashion? I mean, that all happened after he left office.
Yeah, I don't see either the New York case, that's the New York State criminal case, being affected by this, or the Mar-a-Lago case. One is really stuff that happened before he was president, or personal, non-official conduct while he was president. And then Mar-a-Lago is all about the illegal retention of documents after he was president. So I don't think those are covered. But I can't stress enough how big a loss this was in terms of, they basically said that the civil standard, that official presidential conduct, even if it violates criminal law, is subject to absolute immunity. And the only remaining issue is the factual issue about whether certain conduct can be described and accurately described as official versus unofficial. But the court said there's a presumption that the activity is official. So this is, I think, not just a huge loss for this administration, but I just think this is a huge loss in terms of the American public and our relationship to the presidency, where the president is given just really a blank check in terms of his conduct.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.